I wanted to provide a number of questions and answers, or FAQs, for the California rulemaking process. For those who are not familiar, I put together these questions and answers for a lot of the queries that are most often posed regarding the rulemaking process here in the state of California. So let's get started. First, which executive branch entity oversees the California rulemaking process to ensure that state agencies and departments follow the APA, the Administrative Procedure Act? And that's the Office of Administrative Law, OLA, which is housed in the Government Operations Agency. Does a regulation have to be called a regulation in order for the APA to apply? No state agency is allowed to issue, utilize, enforce, or attempt to enforce any guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule which is a regulation unless it has been adopted as a regulation. Can OAL make a determination whether an agency guideline, criterion, bulletin, manual, instruction, order, standard of general application, or other rule that has not been adopted as a regulation? Yes. OAL must file its determination upon issuance by OAL in a filing with the Secretary of State, as well as make its determination known to the agency that adopted that guideline, criterion, bulletin, the governor, and the legislature. It also publishes its determination in the California Regulatory Notice Register within 15 days of the date of its issuing that determination. Can an interested person petition a state agency requesting the adoption, amendment, or repeal of a regulation? Yes, this can be done. This petition must state specified information in quote a clear and concise manner. What does a state agency have to do with the petition to adopt, amend, or repeal a regulation? That state agency must notify the petitioner in writing within 30 days if the agency denies the petition, indicating why the agency has reached its decision on the merits of that petition. Does the APA apply equally to all three branches of government? No, it does not apply to an agency in the judicial or legislative branches of state government. Does the APA apply to all documents prepared by an agency? Nope, it doesn't apply to a legal ruling issued by the Franchise Tax Board or the State Board of Equalization. It doesn't apply to forms or instructions. It also doesn't apply to internal management of an agency or any criteria or guidelines used for internal operations of a state agency. What is the statutorily defined purpose of a regulation under the APA? It's to implement, interpret, or make specific or otherwise carry out the provisions of a statute. Does a state agency have to estimate the cost of a proposed regulation? Yes. And that cost impact means the amount of a reasonable range of direct costs or a description of the type and extent of direct costs that a representative private person or business necessarily incurs in reasonable compliance with the proposed regulatory action. Next, what is the difference between a regular rulemaking and an emergency rulemaking? Well, all regulations are regular unless they meet the definition of an emergency. And an emergency means a situation that calls for immediate action to avoid serious harm to the public, peace, health, safety, or general welfare. What does it mean if a state agency has a rulemaking for a major regulation? This is a regulation that will have an economic impact on California business enterprises and individuals in an amount exceeding $50 million as estimated by the adopting agency. Are state agencies required to file any rulemaking documents with the Secretary of State? Yes, every state agency must send to the Secretary of State, SOS, a certified copy of every regulation adopted or amended by it, except one that is a building standard. Also, agencies are required to send to the Secretary of State a certified copy of every order of repeal of a regulation. When do adopted regulations take effect in California? A regulation or an order of repeal of a regulation is required to be filed with the Secretary of State, and it becomes effective on a quarterly basis: January 1, April 1, July 1, and October 1. What is the CCR, the California Code of Regulations? The CCR is the official compilation of all regulations in the state, over 60,000 of them by my count. What is the California Code of Regulations Supplement? The CCRS, or the CCR Supplement, is the official publication of weekly updates of the CCR. What is the California Regulatory Notice Register? The CRNR is the official publication of notices of proposed actions by state agencies. A summary of all regulations filed with the Secretary of State in the previous week. Summaries of all regulatory decisions for disapproval of regulations, and other relevant materials and determinations. Is a presumption of a regulation's validity created by its publication? Yes, the publication of a regulation in the CCR or the CCR supplement raises a rebuttable presumption that the text of the regulation as published is the text of the actual adopted regulation. Are the courts required to take judicial notice of regulations? Yes, the courts must take judicial notice of the contents of each regulation which is printed or which is incorporated by appropriate reference into the California Code of Regulations as compiled by the Office of Administrative Law. What is the main stated purpose of the state's APA? It is the purpose to establish basic minimum procedural requirements for the adoption, amendment, or repeal of administrative regulations. Does the APA require a state agency to consult with interested parties? No, it does not. But a state agency that is considering adopting, amending, or repealing a regulation may consult with interested persons before they initiate regulatory rulemaking. Does a state agency need to provide notice of an emergency regulation it proposes? At least 5 working days before submitting an emergency regulation directly to the OAL, the adopting agency is generally required to send a notice of the proposed emergency action, including certain information to every person who has filed a request for notice of regulatory action with that agency. How may a regulation be adopted as an emergency regulation? Well, if a state agency makes a finding that the adoption of a regulation or order of repeal is necessary to address an emergency, then the regulation or the order of repeal of a regulation may be adopted as an emergency regulation. Does the agency need to make any sort of finding? Yes. Any finding of an emergency must include a written statement that contains specified information, as well as a description of the specific facts demonstrating the existence of an emergency, as well as the need for immediate action, and demonstrating by substantial evidence the need for the proposed regulation to effectuate the statute. What does the APA deem to not require an emergency finding? A finding of emergency based only upon expediency, convenience, best interest, general public need, or speculation, those findings are not adequate to demonstrate the existence of an emergency. How long does an emergency regulatory action remain in effect? No more than an initial 180 days, but the OAL may approve not more than 2 readoptions, each for a period not to exceed 90 days, hence another 180 days. However, readoption is only to be permitted if the agency has made substantial progress and proceeded with diligence to comply with specified requirements. What must each agency make available to the public upon request of the public? A copy of the express terms of the proposed regulation, an initial statement of reasons, usually referred to by its acronym ISOR, ISOR, and the ISOR is used for proposing the adoption, amendment, or repeal of a regulation. Also, the economic impact assessment that's required, identification of each technical, theoretical, and empirical study, report, or similar document upon which the agency had actually relied when they adopted the regulation, as well as a description of reasonable alternatives to the regulation and the agency's reason for rejecting those alternatives. And finally, facts, evidence, documents, testimony, or other evidence on which the agency has relied in its rulemaking. What is required to be included in the statement of reasons? Among other items, it must contain a statement of the specific purpose of each adoption, amendment, or repeal, the problem that the agency intends to address, and the rationale for the determination by the agency that each adoption, amendment, or repeal is reasonably necessary to carry out the purpose and address the problem for which it is proposed. What adverse economic impact must be assessed by a state agency in a rulemaking? A state agency is required to assess the potential for adverse economic impact on California business enterprises and individuals that avoid the imposition of unnecessary or unreasonable regulations or reporting, record keeping, or compliance requirements. What is the economic impact assessment that must be done for a non-major regulation? Well, for non-major regulations, a state agency um, that is proposing a regulatory action must prepare an economic impact assessment that basically assesses whether and to what extent it will affect the following: the creation or elimination of jobs within the state, the creation of new businesses or the elimination of existing businesses within our state, the expansion of businesses currently doing business within our state, and the benefits of the regulation to the health and welfare of California residents, worker safety, and the state's overall environment. What is the economic impact assessment that must be done for a major regulation? So remember, one that is estimated to cost business $50 million or more. Each state agency then must prepare a standardized regulatory impact analysis, SRIA, which we generally call a SRIA. And this includes the creation or elimination of jobs within the state, the creation of new businesses or the elimination of existing businesses in the state, the competitive advantages or disadvantages of businesses currently doing business within the state, the increase or decrease of investment in the state, the incentives for innovation in products, materials, or processes, and the benefits of the regulation, including but not limited to benefits to the health, safety, and welfare of California residents, as well as worker safety, and the state's environment and quality of life, among other benefits that have been identified by that state agency. What is the purpose of the regulatory impact analyses? It basically is to inform the agencies and ultimately the public and the regulated community about the potential economic consequences of regulatory choices. It does not reassess statutory policy. What is the baseline for the regulatory impact analysis? The baseline is the most cost effective state or set of regulatory measures that are equally effective in achieving the purpose of the regulation in a manner that ensures full compliance with the authorizing statute or other law being implemented or made specific by the proposed regulation. Is there any review of a standardized regulatory impact analysis, SRIA, for major regulations? Yes, the state agency that has prepared a standardized regulatory impact analysis must submit that analysis to the California Department of Finance upon the agency completing the SRIA. What's the minimum amount of time required to be provided for a regular rulemaking project? At least 45 days. To whom does an agency have to mail a notice of regulatory action? It goes to every person who has filed a request to receive this sort of notice, as well as a representative number of small business enterprise or their representatives that are likely to be affected by the proposed action. Are there other required recipients of proposed regulatory actions by an agency? Yes, they also have to be published in the California Regulatory Notice Register, the CRNR, as well as be posted on the state agency's website, if the agency, of course, has a website. For how long a period is a notice of proposed regulatory action effective? It cannot exceed 1 year from the date of the original notice. Otherwise, a new notice of proposed action must again be issued, which starts the formal process anew. How are state agencies required to increase public participation and improve the quality of regulations? They're required to involve parties who would be subject to the proposed regulations in public discussions regarding the proposed regs when the proposed regulations involve complex proposals or a large number of proposals that cannot easily be reviewed during the regular comment period. What is the notice of proposed regulatory action required to include? A statement of the time, place, and nature of proceedings for adoption, amendment, or repeal of the regulation, reference to the authority under which the regulation is proposed, a reference to the particular code sections or other provisions of law that are being implemented, interpreted, or made specific, and an informative digest that's drafted in plain English in a format similar to the Legislative Council's digest. What is required to be included in the informative digest? Quite a bit of information, but basically a concise and clear summary of existing law and regulations, the proposed changes, a policy statement overview, declarations regarding adverse economic impacts, descriptions of all cost impacts, et cetera, et cetera. What happens if a state agency makes an initial determination that the action may have a significant statewide adverse economic impact directly affecting business? Then the state agency is required to include specified information in that notice of proposed action. What is the information required if the agency determined there's a significant statewide adverse economic impact on business? Then identification of the types of businesses that would be affected, as well as a description of the projected reporting, record keeping, and other compliance requirements that would result from the proposed action, and some additional specified statements are to be included. What happens if a public hearing is held on the regulation? If it is, then both oral and written statements, arguments, or contentions must be permitted to be submitted, and the agency may impose reasonable limitations on oral presentations at that hearing. What happens if a public hearing is not scheduled? Then the agency must give any interested person the opportunity to present statements, arguments, or contentions in writing. Now, what happens on the other hand if somebody asks for a public hearing? Then the APA requires the public hearing to be held no later than 15 days prior to the close of the written comment period, so long as an interested person submits in writing to that agency a request to hold a public hearing. Is a state agency required to consider submitted comments? Yes, the agency must consider all relevant matter presented to it before adopting, amending, or repealing any regulation. What must be included in the final statement of reasons after the agency has adopted a regulation? This we know by its acronym FSOR or FSOR. Remember, the initial one is ISOR, ISOR. The final statement of reasons, the FSOR, is basically an update of the information that was contained in the ISOR, a determination of whether the regulation imposes a mandate on local agencies or school districts, as well as a summary of each objection or recommendation made regarding the specific proposal, together with an explanation of how the proposed regulatory action has been changed to accommodate any objection or recommendation, or if not, the reason or reasons for making no change, as well as a determination with supporting information that no alternative considered by the agency would be more effective in carrying out the purpose for which the regulation is proposed. And ultimately, it also has to include in the FSOR an explanation setting forth the reasons for rejecting any proposed alternatives that would lessen the adverse economic impact on any small businesses. Next, can an agency stop with its rulemaking project before its conclusion? Yes, if the agency decides not to proceed with the proposed regulatory action, then it has to deliver notice of its decision to the OAL for publication in the CRNR. Does an agency need to make its rulemaking file available to the public for inspection and copying? Yes, it does. So, what are the 6 statutory standards that the Office of Administrative Law uses to evaluate regulations? They are necessity, authority, clarity, consistency, reference, and non duplication. Let's go through them. What is necessity? It means the record of the rulemaking proceeding demonstrates by substantial evidence the need for a regulation to effectuate the purpose of the statute, court decision, or other provision of law that the regulation seeks to implement, interpret, or make specific. What is authority? It means the provision of law which permits or obligates the agency to adopt, amend, or repeal a regulation. What is clarity? It means written or displayed so that the meaning of regulations will be easily understood by those persons directly affected by them. What is consistency? It means being in harmony with and not in conflict with or contrary to any existing statutes, court decisions, or other provisions of law. What is reference? It means the statute, court decision, or other provision of law which the agency is going to implement, interpret, or make specific by adopting, amending, or repealing a regulation is set forth. What is non-duplication? It means that a regulation does not serve the same purpose as a federal or state statute or another existing regulation. Is OAL limited in its review of an agency regulation? Yes, in reviewing regulations, OAL is to restrict its review to the regulation itself and the record of the rulemaking proceeding. What happens if the agency regulation complies with the 6 standards of review? Then OAL is required to approve the regulation if the agency complies with the standards and forward it on to the Secretary of State. What happens if OAL rejects a regulation? Then OAL must return the regulation to the adopting agency along with an explanation of the regulation's deficiency. OAL must also notify the Department of Finance of all regulations returned by it. Who reviews the SRIA, the Standardized Regulatory Impact Analysis? The Department of Finance, as well as the Office of Administrative Law. What are the only 2 actions that OAL can take on a regulation pending before it? OAL is required to either approve a regulation submitted and then send it along to Secretary of State for filing, or it has to disapprove the regulation within 30 working days after the regulation has been submitted. What happens if OAL disapproves a regulation? Then OAL has to return it to the adopting agency within that 30 working day period, and also accompany that with a notice specifying the reasons that OAL is disapproving the regulation. So on what basis can OAL disapprove a regulation? Well, a regulation cannot be disapproved unless it failed to comply with one or more of the 6 statutory standards of review or some other provision of the APA. What can the adopting agency do if OAL disapproves its regulation? It may be rewritten and resubmitted within 120 days of the agency's receipt of that written opinion by OAL. The agency does not have to comply with the notice and public hearing requirements unless the substantive provisions of the regulation have been significantly changed, in which case a new 45-day comment period begins. Can the OAL's decision be reviewed? Yes. The agency must file a written request for review with the Governor's Legal Affairs Secretary within 10 days of receipt of the written opinion provided by OAL. The request for review must include a complete statement along with other specified information as to why the agency believes the decision is incorrect and should be overruled by the governor's office. What can OAL do if its decision is appealed to the governor's office? Well, OAL is required to file a written response to the agency's request with the governor's legal affairs secretary within 10 days and deliver a copy of the OAL response to the agency in the same on the same day that it was delivered to the California governor's office. How long does the governor's office have to review the OAL decision once the petition has been filed? The governor's office has to provide that requesting agency an OAL with a written decision within 15 days of receipt of the response by OAL. What happens if the governor overrules OAL's decision? Then the OAL must immediately transmit the regulation to the Secretary of State for filing, and the governor must immediately transmit to the committees on rules of the two houses of the legislature a statement of the governor's reasons for overruling the decision of OAL. How long is OAL's review of an emergency regulation? They must be reviewed by OAL within 10 days after their submittal. OAL must allow interested persons at least 5 calendar days to submit comments on the proposed regulations. Can the legislature ask OAL to review any regulations? Yes, at the request of any standing, select, or joint committee of the legislature, OAL is required to initiate a priority review of any regulation or group of regulations or series of regulations that the committee believes does not meet the 6 standards. What must an agency do with OAL's request to repeal a regulation? Well, no later than 60 days following the receipt of an order to show cause why a regulation should not be repealed, the agency is required to respond in writing to OAL. Does the governor's office play any role regarding OAL's proposal to repeal a regulation? Well, the governor, within 30 days after OAL has delivered the statement specifying the reasons for its decision to repeal, they may overrule OAL's decision, and in that case, the regulation remains in full force and effect. Is the legislature made aware of the governor's actions? Yes, the governor is required to transmit to the rules committees of each house of the legislature a statement of the governor's reasons for overruling OAL's decision. What happens if the authorizing statute is repealed or it becomes inoperative? Then OAL is required to order the adopting agency to show cause why the regulation should not be repealed for lack of statutory authority, and they have to also notify the legislature in writing of this order. Can the validity of a regulation be challenged in court? Yes. Any interested person may obtain a judicial declaration regarding the validity of any regulation or order of repeal by bringing an action for declaratory relief in Superior Court. What is the test that is used by the court to invalidate a regulation? For a regular rulemaking, the regulation may be declared to be invalid for substantial failure to comply with the APA. With an emergency rulemaking, the regulation may be declared to be invalid upon the grounds that the facts cited or recited in the finding of emergency do not actually constitute an emergency here in the state. Are there other grounds for a regulation to be declared invalid? Yeah, the agency's determination, for example, is reasonably necessary to effectuate the purpose of the law, or the agency declaration is in conflict with substantial evidence on the record. That is also a ground for being declared invalid. Now, what is the only evidence that a court can consider? The rulemaking file itself, the finding of an emergency, an item that is required to be included in the rulemaking file but is not included, and any evidence relevant regarding whether a regulation used by an agency is required to be adopted under the APA. Are there certain state actions that are not subject to the Administrative Procedure Act in California? Yes. This includes water quality certifications, waste discharge permits, confirmed detections under the Health and Safety Code, and other certain specified orders or guidance under California's Water Code or California's Health and Safety Code. What's an underground regulation? It's one that did not follow the required process pursuant to the APA, but is being used nonetheless. For an emergency regulation, what are not the bases for finding that it's an emergency? A finding of emergency based only upon expediency, convenience, best interest, general public need, or speculation is not adequate to demonstrate the existence of an emergency. And finally, when is a state agency not required to comply with the APA? An agency can only be exempted from the APA by a statute that specifically exempts that agency from the reach of California's APA and the APA requirements. That concludes my frequently asked questions regarding the California rulemaking process.